thank you very much indeed for the organisers for asking me to speak. I also realised that you weren't, I think, of being able to see me. Do you have, can you actually see me now as well? Doesn't matter. As long as you can see my slides and hear me, that's probably the significant points there. I'm going to focus on two issues, but particularly the nature of the tax nexus requirements. I'm going to take as given, and I think this develops from what Julien Cocotte was just saying, I'm going to take a statement from Stjepan Gadzer's book on business taxation, where he says the prevailing view in contemporary tax scholarship is that general international law poses limits not only to enforcement facet of tax jurisdiction, but also to its substantive facet. And I am concerned with the substantive or the legislative facet. While the nature of the limit is often not expressed in a wholly consistent manner among different scholars, a common denominator can be identified in the form of a requirement for a qualifying connection. That's the nexus connection between the state wishing to exercise its taxing power and a particular set of facts relevant for taxation. Only when this qualifying connection is established is the exercise of tax imposing and tax collecting powers of the state lawful from an international tax perspective. This qualifying connection is often labeled as the tax nexus, and that's the background to the discussion. I am assuming that public international law requires a tax nexus, and I want to discuss as my first topic, what are the elements of a tax nexus? I will just say, Eduardo, you are the only person I can see. So if you can't hear me, make some sort of sign. But if everything's okay, from time to time, just give me a thumbs up that everything's all right there. So my purpose is to look, sorry, have the slides moved?
Yeah, your slides are not moving.
Why don't you use Zoom rather than this Microsoft thing?
I don't know. Put the slideshow maybe. Yeah, it's okay. It's okay like this. We can see.
Okay, I'll go back and try and see whether I can get it. If they don't move, let me know. Can you see the slide that says objective?
Yes.
Yeah, okay. 2 points I'd like to discuss. The requirement of an adequate or sufficient nexus. What nexus with a country is adequate or sufficient to allow that state taxing rights over a particular tax subject or a tax object? And also a linked question, how do you resolve competing nexus claims where two or more states can show an adequate or sufficient nexus? How do you deal with the conflict between those two? Do you see a photograph there?
Not yet.
Not yet.
Okay, let's go back. Can you see a photograph now?
Yes.
Yes.
Okay. That's a photograph of my grandfather wearing the uniform of the Royal Army Medical Corps in the British Army in Egypt during the First World War. The reason that I introduce you to my grandfather is to ask a question about him. My grandfather happened to be born in Libau in Courland, which is now Liepāja in Latvia. He would be a Latvian citizen. The question I ask is whether the fact that my grandfather was born in Latvia is sufficient to allow Latvia to tax my worldwide income. It's a nexus with Latvia. I am told that I could possibly claim Latvian citizenship. And frankly, if the British government carries on as it is doing, I might well exercise that right. But is it a sufficient or an adequate nexus to tax me? That's the reason for raising that question. Incidentally, the lady in the corner that my grandfather is dreaming of became my grandmother. At the time, they weren't yet married. Clearly, the photography studio was able to impose her photograph The only thing I find rather surprising is that I actually thought my grandfather joined the army to escape marrying my grandmother. So it's a little surprising that he was dreaming of her there. Now, leaving my grandfather aside and moving, I hope, to the next slide. Do you have a slide about adequate sufficient nexus?
Yes.
This is going to repeat a little bit of what Julianne said, and it's drawn on what I wrote in my chapter for the 50th anniversary book for the International Tax Group. There are a number of factors that go towards whether or not a nexus is adequate or sufficient. Firstly, it won't be very difficult for people to understand with this background that it may depend upon the particular type of tax. Some forms of nexus are justifiable for some taxes, but not for others. For example, for income tax, we are well acquainted with the idea that the nexus of residence or source of income is an adequate nexus. And a little later on today, we are going to discuss whether citizenship is an adequate nexus. We know that there are one or two aberrant countries that use that as a nexus, but is it actually really an adequate nexus in this day and age? VAT, we know consumption, taxes on estates, more long-term connections like domicile or habitual residence. I won't go into it further, but obviously whether these are sufficient is linked to the underlying principle underlying the tax concern, for example, the ability to pay. Also, again, as Julianne mentioned, what's an adequate nexus may depend upon the type of taxpayer. For example, for income tax, an individual taxpayer, the nexus of residence makes sense. You can identify where an individual is resident because they're physically present. It's increasingly difficult to convince oneself that residence makes any sense when one is talking about corporate taxpayers. And therefore, there's much to be said for looking at source rather than residence for corporates. For VAT, if you're looking at, for example, a self-supply charge, really you can only look at that in terms of a business taxpayer rather than an individual. Inheritance tax, for example, a trust, you may be looking at a different rule for a trust than for an individual, looking back to the history of the trust and the domicile or residence of the settlor. Other factors that may have an impact on what is an adequate or sufficient nexus, administrative workability is clearly extremely important. If one's looking at efficiency of the tax system, recognizing a nexus that is administratively very difficult to operate makes it hard to say that that is an adequate or sufficient nexus. So, for example, citizenship in the case of non-residents may be a nexus, but is it administratively workable? We know the difficulties that are created for accidental Americans who happen to have US citizenship but are living abroad because of the claim of the US to tax on the basis of citizenship. Similarly, as a matter of efficiency of the tax system, what is adequate or not should also have regard to the robustness to avoidance. A nexus that can easily be open to avoidance is not a very attractive nexus and one that may be regarded as inadequate or insufficient. Corporate residence based on incorporation, for example, and even for that matter, central management and control may not make sense to have that as your nexus when it's so easy to determine for a company to incorporate in a particular jurisdiction. Linking actually between the two different parts of my discussion today is also the question of whether avoiding double taxation, that is a factor that also goes towards adequate or sufficient nexus. there may be some links with a country that are more likely to cause problems of double taxation, and therefore are less attractive as the nexus, as opposed to other forms of link with a country. I identify citizenship here, where you are taxing your citizens whether they are resident or not. That is almost automatically going to create problems of double taxation for non-resident citizens. Does that reduce the attractiveness of citizenship as a sufficient nexus, because it may almost automatically lead to double taxation? Other forms of nexus may lead themselves to relatively simple measures for avoiding double taxation. For example, if you're using source as a link with a country, exempting its source is somewhat easier to apply than taxing in the state of residence and then granting credit or exemption. So there's an attraction in using the source taxation, because it can more easily be moderated to avoid double taxation. Border tax adjustments on exports are much more complicated than taxing entirely on an origin basis, hence the long-term plan to perhaps move VAT towards an origin basis. Perhaps finally, in this section on what is an adequate or sufficient nexus, it's important to recognize that what is adequate or sufficient can vary over time. We see this very clearly with regard to permanent establishment. The concept of permanent establishment as a connecting factor for source taxation may have made sense 100 years ago, when physical presence, a fixed place of business, or an agent would have indicated the right to tax for most businesses. It no longer makes a great deal of sense in the current digitalized world, and therefore raises the question whether permanent establishment should be dispensed with, or some alternative approach should be adopted, such as Pillar 1. Equally, citizenship may have made sense at the time when the US introduced income tax a little over 100 years ago, and there would have been a relatively small number of US citizens living abroad. Now that there are a large number of US citizens living abroad, entirely understandable. If I was a US citizen, I'd also want to live abroad. Therefore, it may be that citizenship might have been a sufficient or adequate nexus 100 years ago. It may be too problematic now. These are all issues that we'll come back to later. Overall, I hope that what I've done there is to raise with you some questions for consideration. That is, what are the principles that should be underlying the recognition of an adequate or sufficient nexus claim? Let me then turn to the second order issue, and I'll just reassure myself that, Eduardo, you can see a slide that says second order issue.
Yes.
Yep, lovely. If we then turn to the second order issue, and that is, assuming that there are two or more states that have a claim to tax on the basis of an adequate or a sufficient nexus, how do we resolve issues of conflict? And that ties in to questions of fairness in taxation, because how we resolve that conflict directly relates to how we recognize the right of one state versus the other to tax particular tax subjects or particular tax objects. And so I wanted to move the thinking on a little bit to look at this question. I think the first point to note is that there are two types of conflict here. There are conflicting definitions of connecting factors. We're used to this when we're looking, for example, at tax treaties, where two or more states may both claim that a particular taxpayer is a resident of that state, and both of them therefore have residence nexus taxation. So first type of conflict, conflicting definition of connecting factors. Second type of conflict, and again we're used to this, is two different nexus claims based upon a different type of nexus. The classic residence versus source conflict, where one state claims taxing rights as the source of income, the other one as the residence of the taxpayer. In both cases, the conflict can be resolved by recognizing the relative strength of the claims and then by bilateral or multilateral agreement between the states. Very briefly on conflicting definitions of connecting factors such as dual residence, very little work has been done on coordinating and trying to achieve a single agreed definition. Instead, as you know, we have tiebreaker rules in tax treaties. Perhaps I should qualify that by saying I suppose that those who specialize in VAT would say there has been much more focus on place of supply on a consolidated single basis for VAT. One little point I noted in the July EU proposals for tax fairness was a proposal to harmonize the definition of residence for cross-border workers, which is an interesting starting point. But I think there's a much broader question here of potentially seeking international agreement on harmonization of some of the connecting factor definitions. If I turn then to the different issue, and that is two or more states have different nexus claims, how do we resolve the conflict there? Well, that may be based on the recognition that some nexus claims are stronger than others. For example, source claims may be stronger than residence claims in respect of certain categories of income. Income from land, for example, we would recognize a stronger claim of the state of where the land is situated, the state of source. To a large extent, the work of the four economists 100 years ago was using economic allegiance to recognize that for certain types of income, the claim of the source or the resident state was stronger, and our tax treaties implement that to the present day. It may be that what is happening with Pillar 1 is that one is recognizing that the claim of the market jurisdiction to tax the residual profit above a normal return, that is a stronger claim, one that has not been recognized up till now, but that is the underlying rationale that one might put for amount A in Pillar 1. Again, just as I suggested when one is looking at what is an adequate nexus, which nexus has the stronger claim is also linked to the underlying rationale and principles of the tax. Which of two completing claims prevails may also be based on administrative workability and on robustness to avoidance. So these two matters that I referred to about 10 minutes ago as important in determining whether a claim of nexus is adequate or not, they're also relevant to the conflict between claims, where there are two claims, one of which has much greater administrative workability. It's much simpler to operate. It makes sense to give priority to that claim over one with a high compliance cost. So give priority to low compliance costs as opposed to high compliance costs. Similarly, claims that have a greater robustness to avoidance. There is logic in giving priority to those over ones where there's a high risk of avoidance. More broadly, and this is moving perhaps away from established approaches towards fairness in allocation of taxing rights, competing claims need to be resolved on an overall view of the balanced allocation of taxing rights. And I'm not using that phrase here. I'm taking it from the European Court, but not using it in its European use as a justification for restriction, but a much broader concept of balancing the allocation of rights to tax between different states. All states should be guaranteed through this process the rights to tax that are commensurate with their needs. That's not looked at necessarily on a tax by tax basis, but overall, I think we would agree that international equity requires that states receive an adequate allocation of taxing rights commensurate with their needs. And that includes reflecting the needs and the requirements of developing countries and broader economic policy goals. For example, taking into account the UN's Sustainable Development Goals in looking at the balance of allocation between taxing rights. That raises an interesting question, and that is, in resolving this conflict and looking for a balanced allocation, should the process be what I think we can characterize it at the present moment, and that is largely a political process in which the power of the countries leads to the outcome, where the more powerful country in economic terms, in trading terms, in investment terms, is likely to win out in the conflict? Or should it be a broader approach that reflects economic criteria linked to the needs of a country? And I was almost tempted here to try and put a little equation into the slides. Clearly, the claim to overall tax rights of a country should be linked to the size of its population, inversely linked to its per capita GDP. The poorer the country, the greater its needs. The richer the country, perhaps the less its needs. It should also be related to the level of corruption. No point in giving taxing rights to a country if 90% of the tax collected is going to be siphoned off in corruption, and broadly related to efficiency in the use of capital. I'm certain that one of my economist colleagues could probably turn that into a suitable equation. A question I'll come back to, and that is whether value creation, which we're told underlies international tax, at least in BEPS 1.0, reflects correctly the needs of countries for tax revenue, or whether it's an inappropriate basis for allocating balanced allocation of rights between countries. If we were to be adopting economic criteria, then certain forms of nexus are more appropriate and stronger than others. Residence is stronger and more appropriate if all states are at a similar stage of development. Source would be more appropriate if all states were similarly endowed. The fact is that all states are not at the similar state of development, and source and states are not all that similarly endowed. Hence the conflict between claims based on residence and based on source. Consumption is approximately fair if all states are roughly equally wealthy, and consumption is a rough approximation of the wealth and the needs of a state. Again, it's very hard to see how local value creation actually reflects the needs of a state for tax revenue. Finally, and this perhaps is a question to bear in mind when one's looking at Pillar 1 and Pillar 2, if we are taking a broader approach to the allocation of taxing rights, or if you like, the resolution of conflicts of Nexus, looking at a broader view, should we recognize the right of a state to impose tax if that state is not going to exercise those rights? If a state declines to enact an income tax or a consumption tax, would it be appropriate to recognize the right of jurisdiction of that state? For example, when we come to Amount A under Pillar 1, we know from the blueprint how one might compute the amount of Amount A and allocate it to different countries. But what if that country isn't going to tax Amount A? Should there be a reallocation? I don't want to make Pillar 1 even more complicated than it is, but does it make any sense to allocate a part of Amount A to a country if it's not going to tax those sums? Let me end with another photograph. This is a photograph of a bunch of men who appear to have wandered from the US into Mexico. I think that's President Trump on the left, and he doesn't seem to have noticed that there's actually a hole in the wall, and that he's just walked through it. I don't think a wall is going to be very effective if it's got a great hole in it. The reason I put that here is to again ask the question, what is an adequate nexus? If a country wishes to put up a wall to keep out the residents of another country, why doesn't it fund that wall by taxing the residents of the other country? It is, after all, intended to have the effect of keeping out those residents. Why doesn't President Trump just tax Mexicans to fund the wall? It would probably be politically rather attractive to do so. One answer might be, well, he couldn't collect the tax. Well, I'm not certain that's right, because any Mexican visiting the US, any Mexican with a bank account in the US, any Mexican employed by a company which is a subsidiary of a US company, you could enforce in one way or another. There will be some Mexicans against whom you could not enforce the tax, but they wouldn't be able to travel to the US. Otherwise, they'd have to pay the tax. The answer has to be, I think, that presence on one side of a wall is not an adequate nexus to tax. It may be a nexus, but it is far from being adequate. And so that picture reminds us that there are limits to claims to tax that a country may assert, and that it would be contrary to international law to seek to claim on certain bases. With that, I have no idea whether anyone's been able to hear that or see that, but thank you very much indeed if you have been listening for listening. Thank you.